All right, so officially, welcome to Unit 3. My name's Emily Voss. I am the coordinator for We the People for Virginia, and I'll be your facilitator and timer today. We have joining us three most excellent judges who will introduce themselves shortly. And then they'll ask you to introduce yourselves as well as your teacher. So you all know the process. It'll be your 4-minute statement followed by Q&A from the judges, and then we'll do a nice feedback session where the judges will let you know how awesome you are. All right. So with that, I'm going to hand the reins of power to the judges.
Need to unmute.
Yep. Very powerful person handing over the reins of power. So welcome for being here. Congratulations for making it this far in a very unusual and difficult year. We appreciate that. I like the shot with the social distancing, showing that you're properly social distanced but acting as a team. I appreciate that. I'm Donald Rogers. I retired from teaching history at Central Connecticut State University. I've been doing We the People for many years. It's a great program, and it's an honor that you're part of this. My co-judges are?
My name is Joe Stewart. I teach in the political science at Clemson University in South Carolina. Very much look forward to having a conversation. Relax. We're going to learn what we're going to learn from you about things about the Constitution. I've been doing this for a long time and very much enjoy doing this. And you're certainly off on the right foot by bringing us cookies.
Yeah, no kidding. They're killing us with that.
This is
talk about trying to. That's terrible. They're trying to distract us, Joe. That's what they're trying to do.
That's
but
right.
It's working. I got to tell you, it's working. It's killing me. I'm on a diet, so it's really killing me. Dr. Rogers, that picture, the shot of the three of them, it looks like we're appearing before court this morning, in the three of them sitting up there hearing our case. We want to hear your case this morning, and we will tell you if we have time at the end. This mess that Emily's handing out about, handing off the power. No, she has all the power. She has the cards, and we know that, but you have the power for the next few minutes, and we're glad you do. So thank you for having us in this morning, and cookies for everybody at the end.
Mike, tell us who you are.
Yeah, tell us who you are. Yeah.
I'm Mike Miles from Birmingham, Alabama, and I've lost over 100 pounds in the last year and a half. So get those cookies off the screen. You would do, you're killing me with that.
Students, who are you?
I'm Alec Painter. I plan on attending the U of I at Champaign-Urbana, but I'm undeclared because I have no idea what I want to do. That's okay.
Good for you.
Hi, I'm Emily Fisher. I'm planning on attending the University of South Carolina to double major in international business and economics.
Hello, I'm Tyson Madsen, and I'm planning on attending the University of Illinois for classical archaeology.
Alec, I'm 66 years old, and I'm still not sure what I want to do. So you're in good company this morning.
Who's your teacher? Introduce your teacher, please.
Our teacher's Marshall Schacht.
Hello, thank you for coming to St. Joe today.
Absolutely. So it's a real pleasure to talk with you. By the way, those cookies are really distracting. We'll try to concentrate. So thank you. We look forward to the conversation with you. And to open up the competition, we're going to ask you question number 1. I'll read the question to remind everybody what it's about, and then we'll listen to your statement. Starts with a quotation. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states, unquote. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? Please go ahead.
The creation and expansion of judicial review allowed the authority of the Supreme Court to overrule that of the state, broadening federal supremacy. Originally, Marbury v. Madison established that the court's job is to determine constitutionality, but after the ruling in Barron v. Baltimore, the court's authority was largely hindered. Marshall's ruling that the Bill of Rights only applied to states meant that state laws were beyond the jurisdiction of the court. Due to the 14th Amendment passed following the Civil War, the national government now had the authority to limit the states. Gitlow v. New York began the process of selective incorporation, allowing federal laws and rulings to directly apply to the states, thus opening the door for the system of federal superiority that we know today. Protecting the rights listed within the federal Constitution is done through the process of judicial review, wherein the Supreme Court reviews and decides on the constitutionality of a legislative act.
Please unmute. Please unmute.
So sorry about that.
Go ahead.
Judicial review is a counter-majoritarian practice that was put into place by the framers to protect the minority from the tyranny of the majority. The Supreme Court should be a place free of political leaning or other irrelevant factors that divide us. They are meant to be responsible for having an intimate knowledge and understanding of the Constitution and of all of the rights and liberties afforded within the Bill of Rights and the amendments. If any of these rights are being violated, the court should be the shield that protects the rights of the people, even against their own state governments. Prior to Obergefell versus Hodges, the right of marriage was not protected for the gay community. This was an instance where the court had to use their power of judicial review to protect the rights of the minority. As proof that the court had to use their powers in order to protect them, in which Justice Kennedy clarified it that an individual can invoke a right to constitutional protection when he or she is harmed, even if the broader public disagrees and even if the legislature refuses to act. This is a prime and important example of counter-majoritarian practice as well as judicial activism.
The entire objective of judicial review is to ensure that the rights established in the Constitution are being upheld. For an issue to make it to the Supreme Court, there must be at least 4 votes by the judges in order for the case to make it to the judicial level. The only limit that should be on that process is whether or not the issue revolves a constitutional question and whether or not a right is being violated. The process of judicial review revolves around the interpretation of the Constitution and its amendments, so the judiciary's power needs to stay within those documents. Therefore, anything outside of it should not be considered. Other than that specification, the power of judicial review should not be limited or hindered by any other factors. By its own nature, judicial review is counter-majoritarian, so if limits and restrictions are placed on the judicial review by the majority, any group that isn't in power has little to no protection considering their rights and liberties. In Federalist Paper number 78, Hamilton asserts that the judicial branch is the weakest because it has no influence over the sword or of the purse, no direction either of the strength or the wealth of society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment. Any attempt to take away power from the branch that can only speak with its pen rather than a sword would be a clear attempt to silence and suppress the minority. Thank you.
Thank you. Very good. Very nice presentation. You appropriately cite the case of Barron versus Baltimore, indicating the courts did not apply the Bill of Rights on the state level, until much later under the 14th Amendment. But nonetheless, didn't the courts, the federal Supreme Court, consider and strike down some state laws before the 14th Amendment came along?
I'm not entirely sure if that's correct, considering that the Dred Scott case, they made a mistake in which they did not allow for the right of Blacks to have freedom or slaves to have freedom.
So are there any cases, like the McCulloch versus Maryland, do you know that case?
Yeah.
So,
well, let's move on to something else. You indicated that that justices should have constitutional knowledge. What do we have anything in place that would mean that someone has to have knowledge of the Constitution to be on the Supreme Court?
I'm not aware of any test in place at this current moment. I know that the appointments are just done by the president, And I think every single judge has been a judge before they became a judge at the Supreme Court. And they go through a process where they have to be appointed and then voted on. And I'm sure that their knowledge of the Constitution is a big factor in that voting.
Yeah, to add, with the approval process, if the president were to try to put someone in that has no basis in constitutional law whatsoever, no matter where your party lies, you're not going to allow that. You're not going to feel safe with that.
Talk another minute about term limits. The president of the United States has term limits. The members of Congress don't have term limits, but they have to run every 2 and every 6 years, so their term could be limited pretty abruptly. And yet we allow not just Supreme Court justices, but all federal judges to serve until they're signing a bed sheet with a pen, thinking that they're signing a motion or signing a decision that they're handed down. Does it get to the point with Supreme Court justices where they've given all they can give at a certain age or after a certain number of years and they deserve to retire and let other people come? Or is there a good reason not to limit their time on the bench?
I think the reason for not limiting their time on the court is for the purpose of you gain more knowledge over time and you get wiser as you make more and more decisions. So you get a greater understanding of the Constitution. And I think that actually not having term limits benefits the Supreme Court, because if they were all newer, younger judges, you would constantly be bringing in new opinions and newer people who had not as much experience or knowledge in that case.
To disagree with my peer there, I think at a certain age, I think that you're correct that it is a little dangerous to keep them on the court when at a certain age you might not be completely aware of what's going on. And yes, your constitutional knowledge might be vast, but at a certain time, it's just time to hang up the robe. And so I think besides old age, I don't think there should be a limit on how long someone can be in the role of a judge.
Are there cases that you're aware of where you think that the Supreme Court went too far in reviewing and striking down state legislation?
I don't think so, but I will cite a case, Obergefell v. Hodges, which some people think they went too far. I think that the legislation was too slow, and the Constitution and the Declaration of Independence guaranteed the right to a pursuit of happiness, which can be seen through the right to marriage. And there was no legislation for those same-sex couples that would allow for them to marry, and the legislation was too slow. So the Supreme Court stepped in to promote those civil liberties. And I think it was a good choice, but some would argue that it was not.
To add on to my peer's statement, I think that a big problem with slow legislation is probably the filibuster. It prohibits them from passing it quicker. And I think if we abolish that, I think it would definitely allow for more legislation to pass for rights such as gay marriage.
The filibuster, I'm glad you brought that up. Filibuster is a Senate rule, which could be changed by the Senate. You mentioned the rule of 4, which is a Supreme Court rule. Would you think it would be a good idea to change the rule of 4? If so, in what direction and what difference do you think that would make?
I don't believe that the rule of 4 should be changed. My initial thought on this is that like lowering the rule of 4 or completely getting rid of it, I definitely don't agree with that. They should have the ability to say this is not a constitutional question, even though it got up to us. They should be able to say that this is not our job. And so I definitely would not support getting rid of the rule of 4.
Yeah, this is as much an observation as it is a question. I live in a state where the legislature for 100 years has refused to tackle tough problems, and we just kill time until the courts step in and make us do things. Is the court drawn into things sometimes that they probably shouldn't have to be drawn into because the legislative body, for political reasons, just refuses to act on things until people are being discriminated against so bad that the court has to act? Or is the court overly aggressive in getting into it themselves?
I think actually the court does a good job about staying back when matters of the state are at hand, such as like racial gerrymandering. They definitely stand back and allow the states to deal with that because that's the state's jobs. And I think it's really important that they do that so they don't have too much power and they don't step in when they aren't necessarily needed. However, when it gets to a point where people's votes aren't being valued, then I think it definitely should be an issue of the court.
Yeah, I really would put that blame on the legislation there. Pressure, like forcing the court and pressuring them into doing this is only hurting the people. It's saying, I'm not going to cooperate. I'm not going to do my job. I'm just going to force it all the way up. I think that's incredibly counterproductive.
I think in the past, more specifically the Warren Court, we had a lot of judicial activism where they would go and try to progress these rights. But I think now we are seeing more of, we're waiting, the legislation is waiting until we are forced. Can I finish my statement, please?
Please.
They're being forced to act because of, like you said, rights are being violated. So legislation is waiting too long to act.
Great answer.
Thank you.
Thank you very much. Very much. So you have an audience there. It sounds like very good. Thank you very much. I enjoyed your presentation. You made a strong pitch, throughout your presentation, sort of on the orientation that the Supreme Court is a defender of the Bill of Rights, particularly when you work from Barron, which is a good insight to use that case as a benchmark for the Supreme Court's involvement with state laws. You mentioned good court cases, the Hodges case, Federal 78. You might have said more about that and what its logic was. I'm too bad you couldn't answer my question on what the court's doing before Barron, and because then the reality is the court is already reviewing state legislation. There's a McCulloch versus Barron is probably the most important one of the most important cases in U.S. Supreme Court history, where the Supreme Court struck down a law of the state of Maryland. You probably remember this, that attempted to tax the Bank of the United States. And there's other ones involving the Commerce Clause, the Contract Clause. And so that would have been a really good opening for you to explore, to show that the court's role in reviewing state legislation has actually changed a lot over time. And the constitutional basis was one thing before the 14th Amendment. And of course, as you've argued quite well, that it has changed. We got on to an interesting topic at the end and we didn't have time. I had some more questions for you. I think you're right that the Warren Court was activist and often stepped into, Brown versus Board, for example, stepped in when state legislatures were not acting. And so my question was going to be, do you think that the judicial branch should take on a legislative function when state legislatures do not? And that's a very explosive question, as you might imagine, but that seemed to be the direction in which you were going. And I'm sorry that we had to end the conversation because I would have liked to have heard what you would have said. So a very stimulating presentation, and I very much enjoyed it.
Yeah, I agree. This is very much enjoyed our discussion and wish we'd had some more time. You go from Barron to the 14th Amendment to Gitlow, which is the proper order. I'd like to fill in some blanks there. We get Barron in 1803, the 14th Amendment right after the Constitution, and Gitlow in 1925. So there are things happening in between there. And I would have liked to have heard you talk more about how those are filled in. No discussion of this question is complete without mentioning a Supreme Court case that deals with Judge Miles' home state of Alabama. And when you mention racial gerrymandering, the appropriate case there, Gamillion versus Lightfoot, is the case. Your point was exactly correct, but you could have also taken a shot at Alabama, as I often do when Judge Miles is around. Two other things I would point out. You talk about constitutional knowledge as important on the Supreme Court, and I suspect you're right in an informal sense. In the formal sense, though, remember, the federal judges are the only federal official in the Constitution that do not have a constitutional requirement. Each one of you is constitutionally qualified to be a federal judge. And after having heard you, I would be a lot more confident in one of you than with the other federal judges I've known. And I don't want to promote cynicism, but one of the things you suggest is people get wiser over time. Some people do, others just get older. And I'll let you sort out which is which, but I like your optimism about it, and I very much enjoyed our discussion. Thank you.
Joe, I wish you'd quit looking at me every time you say that. I take it very personally when you say the last part of that, and I know you mean it that way. You mentioned a few things this morning we had not heard before, and I appreciate that. What you were talking about, state legislatures and what they do. Some states do practice racial discrimination. In Alabama, we've turned it into an art form. We've perfected it down here. And if it had not been for federal courts, in the language of some Alabama governors, butting in, our state would be a lot worse place. We're better for having heard you this morning. The last two observations we have to make is, Don, if you had just brought us some milk, we could have forgiven you for the cookies. That was a real problem, but just get us some milk next time. And the last thing I would say, Dr. Rogers, is that the three of us, we felt like we were very blessed today to have one Emily, but this unit gave us two at one time. And that's so we were doubly blessed to have that. You charmed us this morning. Marshall, great job to you too, man. I know how much a part of this you were. Thank you so